Appearances, please. Who's here?
Quashante Short, QASHONTAE
Richard Jordan.
I read your complaint again, and you have not. I'm looking here. What is it? Intentional infliction of emotional distress?
Yes.
Is that the claim here?
Yes,
Okay.
It is.
That's not something that's really justiciable in district court.
I'm sorry. I can't hear you.
I said that's not something that's justiciable in district court. That has to be brought in circuit court.
So you said it's not permissible in district court. It has to be taken to circuit court.
That's an equitable action, yes. Mm-hmm.
I thought only criminal offenses. Well, I guess it would be considered. I don't know if it's criminal or however you want to consider it, but I thought only criminal offenses were brought before the circuit court.
Before we jump into this hearing, let me set the stage, because what you're about to watch is not a normal civil dispute. This is a full-blown courtroom misunderstanding spiraling out of control in real time. On one side, you have a defendant who clearly has no legal background and is genuinely confused about why he's even here. On the other, you have a plaintiff who is absolutely convinced that being emotionally upset automatically converts into criminal charges, felony perjury, and six-figure liability. And in the middle of all that confusion sits a judge who is desperately trying to explain basic legal concepts, like jurisdiction, civil versus criminal law, and what perjury actually means, while being repeatedly interrupted, corrected, and accused of insulting someone's intelligence. What makes this case so wild isn't just the arguments, it's the certainty. The plaintiff is completely confident, while being completely wrong. And the more she argues, the more obvious it becomes that she fundamentally misunderstands how courts work. Stick around, because this hearing doesn't calm down, it escalates.
So will I have to?
What's in your head? I cannot get into what's in your head, man. Mr. Jordan, let me just ask you this: are you planning to represent yourself on this?
To be honest with you, sir, I thought this was just going to be thrown out. We had a date, one date, and nothing else after that. And now I'm being sued for $10,000.
If you think it should be dismissed, you need to file the appropriate motion. You need to file a motion to ask for that.
I will do that. I really didn't know what to expect. This is all new to me. I've never been sued before. I've never, gotten in any trouble. This was just, I don't know. But if that's the process I have to take, then that's what I'll do.
There was also a perjury on there as well. He stated, I can't remember what he stated right now because I don't have it. The document
perjury,
in front of
the short perjury is a criminal charge.
Okay, there were two different charges. There was one that was intentional affliction of pain, which I didn't see that as being a criminal offense, but perjury, I guess that could be considered a criminal offense.
Ma'am, I'm not going to sit here and argue about the legal definition and what's a crime and what isn't. If somebody gets charged with perjury, mm-hmm. that is a criminal felony charge. You have to go through the prosecuting attorney and the police. Okay? So that's what you are alleging.
Yes, the document will show that, and I've also sent forth the messages where he was lying, and it proved he was lying.
Right here, the judge identifies the core problem that will haunt this entire case. It's filed in the wrong court. Intentional infliction of emotional distress is a civil tort, not a criminal charge, and district court simply doesn't have jurisdiction over equitable claims like this. Instead of recognizing that mistake and adjusting course, the plaintiff immediately gets defensive and confused. This is a critical fork in the road, because had she listened, she could have saved herself months of frustration. Courts don't bend just because someone is emotionally invested. Jurisdiction is non-negotiable. And once a judge explains that your claim doesn't belong in that courtroom, arguing about how you personally understand the law doesn't change anything. This is where legal education matters, because confidence without comprehension is about to drive this case straight into chaos.
But that should have been in the case file as well.
Did you put it in there?
I emailed it. I
don't see
sent
that
it.
mentioned in your complaint.
Yes, I emailed that.
Did you amend your complaint?
I didn't have to amend my complaint. I had to get an address for him. So I sent it to the second known address.
No. If you are alleging a different count, you've got to amend your complaint to add it in. You can't, I don't know what you said you did, but you
the last time we spoke, the last time we were in court, I never changed anything. It's just that he was not properly served. So I had to get an address for him in order for him to be properly served. That's what was the last incident that transpired, was for me to get a correct address for him.
That has nothing to do with what I asked you about.
I know you asked me about an amended.
I asked you about what your claim is about. You said intentional infliction of harm, and I assume you mean intentional infliction of emotional distress. And you said perjury. That's the basis for your claim.
Yes, I'll amend the complaint. I thought I had that already in there. I received a document, I guess after I sent the correct address and he got the document, he sent a letter that should be, I guess, in the file. He sent a letter, and
that's
then
his answer, I guess. We're treating it as his answer.
Right. And so I emailed my response to that letter, because in that letter, he lied. And then that's what brought forth the perjury. It was never perjury in the beginning. It was perjury after his response.
This contrast is important. Richard is openly confused, nervous, and honest about not knowing what to expect, and ironically, that actually helps his credibility. Meanwhile, the plaintiff is aggressively confident while misunderstanding nearly every legal concept being discussed. The judge isn't favoring anyone here, he's explaining procedure. And notice how the defendant listens, acknowledges the process, and agrees to file motions properly. That's how courts work. You don't just say something should be dismissed, you file a motion, cite law, and let the judge rule. The irony is that the only person here following legal advice is the one being sued. And that imbalance is about to become painfully obvious as the plaintiff keeps doubling down.
Well, you can't say, listen, he has the right to put whatever is in the answer.
I'm not saying he can't, but
you can't add another count because you don't like or you disagree with what is in his answer.
If he responds and his response is a lie, it's perjury, then my documents will prove that he lied in his response.
No. First of all, do you understand what perjury is?
Yes, I understand perjury is a lie. I know what perjury means.
Perjury is a statement, a false statement made under oath. So
exactly, and I got documents that prove he was lying.
You don't understand. It's a false statement made under oath. Under oath.
That stated a lie.
When did he testify to something that he lied about? It's a false statement made under oath.
Bottom line is, you said it's a criminal offense, so I will send it to circuit court. Are we done here?
No, you don't understand, ma'am. You don't understand.
Are we done here? Are we done here?
Perjury is a false statement made under oath.
I know what perjury means. Are we done
no,
here?
You don't.
Is it a criminal offense or not?
What statement? I don't see anything in the complaint that says he made some false statement under oath.
Because you don't know what happened. You're on the outside looking in. You don't know anything.
But you're the plaintiff. Wait a minute. You are the plaintiff.
Are we done here?
You have to lay out your allegations properly.
Are we done here?
No, we're not.
Exactly what perjury means.
No, we're not.
Do not insult my intelligence.
You have to
do not insult my intelligence.
You have to lay your complaint out. You have to allege this in the complaint. You have
Please
not.
do not insult my intelligence.
Here's where things take a sharp turn into legal fantasy. The plaintiff treats the word perjury as if it simply means someone lied to me. That's not even close. Perjury is a specific criminal offense that requires a knowingly false statement made under oath during a legal proceeding. Not in emails. Not in text messages. Not in someone's court filing unless sworn testimony is involved. The judge is trying, patiently, to explain that distinction, but she keeps circling back to her own definition. This is dangerous, because accusing someone of perjury is not a casual allegation. It's a felony accusation. And throwing that word around without understanding it doesn't strengthen your case, it weakens it dramatically.
It's not about that. You don't think, I don't think you understand what perjury is. It's a
Are we
false
done
statement
here?
made under
Are we
oath.
done here? Are we done here?
I
Please
said
do not
no.
insult my intelligence.
said no.
Do not do that. Do not do that. Do not insult my intelligence as if I do not understand what the word perjury means. Do not. If it's a criminal offense, then it's a criminal offense.
Well, ma'am, it should not have been filed in district court if you want intentional infliction of emotional distress.
Okay, so that's a criminal offense.
Are you going to dismiss it and refile it?
No,
in
I'm
circuit?
not. No, I'm not going to dismiss it. I will file another case in circuit. But as far as I'm concerned,
You can't
no, it
have
will
two
not be
cases on the
dismissed.
ma'am, you can't have two cases going on the same issue.
Well, I'm not dismissing the case. If you want
Well,
to
I tell
dismiss
you
it,
what.
that's up to you. But I, as a plaintiff, am not dismissing the case.
He has to make a proper motion,
Well, that's on him.
but I can also transfer the venue to circuit.
Yes, that's what I thought, because there were other cases that should have been transferred somewhere else.
Okay, I'm going to do that. Ma'am, what about his costs associated with appearing because you filed it in the wrong court?
I need to see because I was not aware, since you said perjury was not on there, I was not aware that a criminal offense for intentional infliction of emotional distress was considered a criminal offense there, that it had to be
I didn't say that.
forward.
That is not what I said.
Yes,
that is not what I said. I said that. No, I didn't. You said that.
Yes, you did. You stated
I said that circuit.
You stated that the criminal. You stated that emotional infliction of emotional distress is a criminal offense, and you stated that perjury is a criminal offense. But you also stated that perjury is not on the document that I placed forth before you. So criminal offense would not.
It's not in the complaint.
Be on there.
It's not in the complaint.
I need you to show me. I need you to show me the document which states that intentional infliction of emotional distress is indeed and in fact a criminal offense, because that's the original offense that was placed on there.
I never said that. I never said that.
Yes, you did.
I never said that.
Yes, you did.
No, I did not. Ma'am,
Yes, you did.
Listen. I'm not going to sit here and go back and forth with you. I will repeat to you what I said.
I'm not either.
I said
so that's two
that
charges.
intentional. You need to be quiet while I'm talking. You need to be quiet. Can you mute her, please?
Because perjury is a criminal offense. It has to go to circuit court.
That will not make her hear you.
Intentional infliction of emotional distress.
This is the emotional breaking point. Once someone starts saying, "Don't insult my intelligence," repeatedly, the discussion has already shifted from legal analysis to ego defense. The judge isn't insulting her, he's correcting her. And courts are allowed to do that. In fact, they're required to. What's happening?
What I said was intentional infliction of emotional distress is something that circuit court has jurisdiction over. I never characterized that as a criminal matter. It is definitely a civil claim, but it is something that can't be done in district court. Now, that's what I said to you. You are on the mistaken belief that circuit court does not hear civil matters because you said, well, I thought circuit court only did criminal. You are the one who are mistaken about the jurisdiction of circuit court because that's what you stated on the record.
I can barely hear what you're saying. Like I said, I'm at the airport. There's a lot of people around.
Ma'am, are you getting ready to go on a trip or something?
No, I actually just came. I had a rental car.
Oh, I see. Okay. Ma'am, this is what I'm doing. I am ordering that this go to 7th Circuit Court. Venue is to be changed because intentional infliction of emotional distress is a circuit court matter outside the jurisdiction of district court. Plaintiff shall pay the filing fees in the receiving court. And I don't know if you asked for a jury trial or not. You did not, it looks like. So there was no jury fee. No further proceedings shall be had after transfer until these costs or expenses are paid. If not paid within 56 days of the date of this order, this case shall be dismissed by the court to which it was transferred.
And what cost am I paying? Hold on. What cost am I paying for?
The filing fees for circuit court.
Why am I paying for filing fees for the circuit court? Because there's been multiple cases that have been brought forth.
Because you filed it in district court, we don't do intentional infliction of emotional distress cases.
Well, I need to see that in writing. I need to see that document in writing that states that
if you want to appeal, if you want to,
I've already skimmed SCAO. I've already skimmed that. I'm reading constantly every day, and I did not see that form on there.
I'm sure that you are. But
yes, I am.
If you want to appeal my ruling, you got 21 days to do it.
Yep, I do.
You got 21 days to appeal it to the circuit court. My ruling. Okay? Thank you both.